Hello, Tenants Queensland and tenant advice workers. My name is Tim. I'm with the Office of the Commissioner for Body, Corporate and Community Management, and I'm going to have a quick chat to you today about our legislation and its impact on tenants and some of the things you might need to know about when dealing with tenants. First things first, just so I remember, under our legislation, tenants are called occupiers. I'll keep talking about tenants as we progress through this presentation, but just bear in mind if you read our legislation or talk to our information officers, they will use the word occupier generally when referring to tenants. Okay, so it should be between 30 to 40 minutes. I haven't exactly timed this presentation, but really is just a taster. And moving forward, please feel free to contact us or to access our web pages, and all the details will be at the end of this PowerPoint. So I will get started on that now. Okay, so yes, this is a tenant information session presented by the Office of the Commissioner for Body, Corporate and Community Management. And what I'm going to talk about today, some hot topics potentially for tenants, are bylaws in bodies corporate, and particularly bylaws around pets and parking, the nuisance provisions of our legislation, which deal with people's behaviour within bodies corporate, and action can be taken under that section in the legislation. Maintenance responsibilities, because it's important for the tenant to know who they need to talk to when they are seeking to have maintenance carried out, their owner or the body corporate. The dispute processes within the Office of the Commissioner for Body Corporate, which tenants have standing to access. So we'll talk about that. Smoking, a hot topic, one of the ones that you requested we talk about. Entry to lots, on-site managers and body corporate managers, who they are, what they do, what powers they have. So I'll go through all of these, and from hopefully a tenant's perspective, and we'll take it from there. Okay, so bylaws are rules for bodies corporate. All bodies corporate have them. They're unique to bodies corporate, so there's not a generic set that apply to all of them. Most bodies corporate have put quite a bit of time and effort into actually tailoring them for their own scheme. Tenants are actually bound by them. And my understanding is under the residential tenancies legislation, they should receive a copy from their landlord or real estate agent when they first move in. But if they haven't, you can get them from the titles office. That's where they're registered. And again, you can go back to your owner or the agent, say, can we please have a copy? So bylaws can be enforced. There is a bylaw breach process under our legislation. So your tenant can either seek to have the bylaws enforced against somebody, or the body corporate or somebody may seek to have the bylaws enforced against your tenant. So you've got obviously the lease conditions, but overarching those are the bylaws. So bylaws cover things like pets, parking, noise, renovations, parties, potentially pool use, cover lots of things. Some of the bylaw documents are quite large. They can be up around the 100-page mark, so they can be big. So yeah, your tenant needs to be aware of them. In terms of enforcing and complying with the bylaws, I guess I'll give an example with pets. So this is a fairly common area of dispute with tenants. They move in with a pet, their landlord's given them approval. They don't actually realise there is a bylaw that requires the body corporate also give them approval. And then the body corporate system, you've not applied. And the tenant says, yes, but I've received approval from my landlord. And then the dispute starts. So in terms of enforcing bylaws, the body corporate committee actually has an obligation to enforce them. Normally they're enforced by a tenant or an owner giving the body corporate what we call a Form 1, which basically alerts the body corporate to the fact that there is actually a bylaw being breached. The body corporate has 14 days in which to respond, to either say we're not going to take action or we will take action. And at that stage, the tenant can decide whether they pursue the body corporate to enforce the bylaw, or they go directly against the person they think is breaching the bylaw. So more often than not, though, the tenant is actually on the receiving end of that, of the bylaw breach process when it comes to pets. So what's likely to happen is the body corporate committee or an owner is going to notice there's a pet there. You're going to ask if there's approval. If there is no approval, body corporate may end up, probably first having a chat with the tenant, and the tenant may say, well, I don't have to. Then they'll receive a breach notice. Breach notices can come in two forms. I won't go into those in detail, but in effect, they're basically saying either you've got to remedy this breach within a certain time frame, or you've got to make sure you don't do it again within a certain time frame. So with regard to pets, it's basically you must remove your pet within 7 days, or you must apply first, and if we don't give you approval, then remove within 7 days, 14 days, whatever it is. Now, if the tenant says, I'm not going to remove my pet or it can't be resolved, then the body corporate has the option of going straight to the magistrate's court to see if fines can be imposed against a tenant, or they can make an application here to our office for to go through the dispute resolution process, which could ultimately culminate in an adjudicator ordering the tenant to remove their pet, or conversely, ordering the body corporate to allow the pet, depending on the circumstances. So your tenant has a right, just to reinforce this, they have a right to ensure that the bylaws are enforced. They have a right to go to the body corporate committee and say, here's a Form 1, please take action against this person that's breaching the bylaws. And if that doesn't end up working out, they have a right to then bring either the body corporate or that person who is breaching the bylaws here to our office for dispute resolution, provided they go through all the appropriate steps beforehand. So pets is a common one for tenants to be on the receiving end of. Parking is another one, because often tenants, if there's a number of tenants in a lot, there may be too many cars for the garage, and they end up parking on common property or in visitors' car parks, and that leads to disputes because normally the bylaws will say you need permission to park on the common property from the body corporate committee, and with respect to visitors' car parks, generally there's no ability for anyone apart from genuine visitors to park in those visitors' car parks. It's part of the development approval for a body corporate. So in terms of tenants trying to seek to have the bylaws enforced, it may be, for example, that the person next door is holding loud parties and is breaching or the tenant is alleging they're breaching the noise bylaw, for example, so the tenant could then take action against that person via the body corporate. I got a question about towing, which is related to parking. Our legislation doesn't deal specifically with towing. The adjudicators have generally said, look, you need to follow the bylaw breach process. Ultimately, we can order that the car be removed, but there may be a common law right for the body corporate to tow a vehicle, and your tenant then may need to get some independent legal advice if that occurs. So, just to reiterate, our legislation doesn't deal specifically with towing. Our adjudicators have kind of basically told bodies corporate you need to come through our processes, but it is a bit of a hot topic, and as I said, there may be a common law right for the body corporate to actually tow somebody's vehicle. There's also a section of our legislation which is the nuisance section, which is a section that your tenant may come into contact with, either because they're seeking to take action against somebody who they say is creating a nuisance, or somebody says they're creating a nuisance. So what the legislation says in effect under section 167 is that somebody who is on the common property or within a lot can't cause a nuisance or a hazard or unreasonably interfere with somebody's use or enjoyment of common property or a lot that they're on. This one gets brought up occasionally around, for example, smoke drift, sometimes around smells, because often there's a bylaw that doesn't actually deal with it. But nuisance can be quite difficult because you've actually got to prove that this nuisance exists. And for example, with smoking, it'd be quite difficult to actually, prove objectively that the smoke is of a nuisance level. I mean, ultimately, you may need to get some sort of a machine to measure the smoke output, and then take action from there. So if your tenant has a dispute with somebody else, we would recommend first seeing if there's actually a bylaw they can seek to have enforced, because that's probably a lot easier than seeking to follow the nuisance provisions and actually prove objectively there is a nuisance. Okay, so that's nuisance. Maintenance. This is another area that's going to be of importance to your tenant. So they have the rights to take on the body corporate to make sure that common property is maintained in good condition. Common property is a lot of obvious things, as you can see up there on the slide, like pools and lawns and roadways. So, for example, if the pool is green and the tenant can't swim in it, yes, they can go to the body corporate and say, hey, to the committee, please, want you to fix it up. You've got a duty to maintain that in good condition. And if ultimately the body corporate says go away, then there'll be a dispute and they can come here to our offices and deal with that. It would be worthwhile, obviously, the tenant keeping the landlord in the loop or the owner in the loop, because if it's something that needs to go to a general meeting, which some matters might be, depending on the amount of cost involved, the tenant can't actually put a motion to a general meeting. That's only something an owner can do. So the owner could do it, or the body corporate committee could do it on behalf of the tenant. But yes, keeping the owner in the loop can sometimes bring two lots of pressure to bear on the body corporate. Sometimes the owner may actually need to, if the body corporate is not being particularly cooperative, requisition an annual general meeting by getting other owners on board to actually demand that a general meeting be held. Just to bear in mind that it's a two-pronged approach often, or a two-pronged attack. Now, in terms of the maintenance responsibilities, sometimes a tenant can get confused about, well, who do I actually go to? Is this a body corporate responsibility, or is this an owner's responsibility? A common example would be, for example, the front door to the tenant's lot. Now, depending on what type of plan the scheme is registered under, so whether it's a standard format plan or a building format plan, will actually determine who's responsible, whether it's the owner or whether it's the body corporate, and then the tenant will know who to talk to. So just quickly, standard format plan, normally things like villas. Building format plan, normally things like high-rise buildings. And the difference is, I guess, what the body corporate's responsible for. So under standard format plan, anything within the boundaries of the lot, which is often a yard, for example, is the owner's responsibility. So the owner would be responsible for the roof, the walls, the structure, and anything outside of that. So, the roadways outside, etc., would be the body corporates. Under a building format plan, the body corporate is responsible for the roof, the outside of the building, any windows and doors on the outside of the building, the structural integrity of the building, roofing membranes providing protection. So, there's a lot more obligation on the body corporate under the building format plan for maintenance. So coming back to that door example, if the door is under a standard format plan, that would normally be the owner's responsibility. If this is a front door in a building format plan that is on the boundary with common property, it would normally be the body corporate's responsibility. So when your tenant comes to you with a maintenance issue, you're going to have to look at that. Utility infrastructure is another quite difficult area because there's a lot of questions you need to ask. Generally, an owner will be responsible for utility infrastructure. So, for example, pipe work, if it's solely within the lot, not within a boundary structure for the lot, and only provides services to the lot. So that's kind of a key question with respect to the utility infrastructure. Hot water, anything to do with hot water is normally the owner's responsibility, but again, that's normally, there's exceptions to every rule. So when it comes to maintenance, you may need to dig a little bit deep with your tenant to find out who you need to talk to get the matter resolved. Entry to a lot. So under our legislation, the body corporate can actually enter a tenant's lot if there is work that the body corporate needs to carry out, or if they need to inspect, if there's any work they need to carry out. When they give the entry notice, they've also got to give it to the owner. It's got to be in writing, and there's got to be 7 days notice unless there's an emergency. So obviously if there's water coming out from under the door and the tenant's away, the body corporate could just enter in that emergency situation. Obviously there's a bit of a crossover with residential tenancies legislation. So you might have a situation where there's a lot going on in the lot, or there's a bit of confusion about who's supposed to be doing what. You might have the agent giving notice to enter to inspect if there's stuff they need to carry out. There may be the body corporate giving an entry notice to see what they need to be carrying out. So yeah, the tenant needs to be aware they could be hit with 2 lots of entry notices, but also 2, that they need to be aware that the body corporate does have a right of entry. So, and it's actually an offence to refuse that entry. Okay, dispute resolution. So there's 3 stages, as you can see up there on the slide. There's self-resolution. So we don't want people just coming here who've not attempted to resolve it with the other party. So, for example, with a bylaw breach, self-resolution would actually include, issuing the Form 1 to the body corporate, for example, and then following up with the body corporate if they don't actually do anything. It's important that, we're trying to encourage people to self-manage, so we don't want to be, intervening at too early a stage. So they have to demonstrate that they've tried to self-resolve it first. Normal first step after that would be conciliation. Most matters come to conciliation next. And so a conciliator, either on the phone or in person, sits down with the parties or talks to the parties over the phone for up to 3 hours. The conciliator can talk about the legislation, talk about adjudicators' decisions, and ultimately the parties may reach an agreement that will resolve the matter. If it's not resolved through conciliation, or if the agreement falls over, or if it's a matter that's not suitable for conciliation, next stage is adjudication, where a legally binding order would be made. So the adjudicators are actually within the office of the Commissioner. They do all their decision-making based on the papers, so there's no actual appearance in person. And yeah, they are legally binding orders. So if they're not carried out, they can be enforced and fines imposed through the Magistrates Court. So a tenant has standing to use our dispute resolution processes. So you can see the word occupier up there. So that would say Tesso as a tenant, they can go against another tenant. As a tenant, they can go against their owner. As a tenant, they can go against the body corporate. So there are options there for the tenant to use our services, and quite often both people in the body corporate and people on sort of the real estate agent side will tell the tenant, oh, you can't do anything, you've got to go through your owner. That is not correct. So tenants do have the right to see that the maintenance responsibilities, for example, and bylaws or breaches are enforced. They can pursue that through us here at the BCCM. Smoking, that was a topic that Tenants Queensland asked us to talk about. It's it's fairly contentious. There's a lot of obviously concern around smoke drift and cancer, and I know the Cancer Council's involved, and there's the Tobacco Act that's put in some restrictions about where smoking can occur. But in a body corporate context, I suppose the overarching issue is that smoking is lawful. So if a body corporate tries to out and out restrict smoking in a unit, they are more than likely going to fail. If somebody challenges it through, if there's a bylaw saying you can't smoke in a unit, that's going to be difficult to uphold. Bylaws may restrict where smoking occurs on the common property, so there may be actually a smoking area, and again, that may be fine. There may be no reason for that to be overturned. Again, it depends on the circumstances. You've obviously got tenancy agreements that can prohibit smoking, so that may, be one way of controlling where smoking occurs within a lot. And as a conciliator, I've had a number of disputes dealing with smoking, and people often come up with quite unique solutions, including one I dealt with a number of years ago, where the tenant agreed that they'd use a hookah pipe and smoke their tobacco through water, and everyone seemed happy with that. But often people will make agreements around how often they smoke on their balcony and things like that. But yeah, there is no ability just to outright stop people smoking. It would be very, very difficult to uphold a bylaw that attempts to do that. And watch this space. I guess, 5-10 years, the landscape may have changed completely, but currently that's where we're at. Okay, so the body corporate has 2 people on its management committee. that are not actually voting member. And one is the caretaking service contractor or the on-site manager, and the other one is the body corporate manager. So there can often be a fair bit of confusion from tenants, particularly about who they're actually dealing with. So when they say the manager said or the body corporate manager said, you need to just clarify who exactly they're talking about. So the on-site manager is engaged by the body corporate to carry out certain duties. They've normally got a caretaking element, and they often can also be the letting agent as well. And this is sometimes where friction can occur because owners are not obliged to use the letting agent. Sometimes they'll go with an external agent or they'll self-manage. And often the on-site letting agent can become a little bit cranky with that. And sometimes they can end up being a little bit uncooperative or even sometimes outright, I suppose, antagonistic towards the tenant in the lot, in that particular lot. So sometimes the tenant can be in the middle of a dispute between the owner and the on-site manager because the owner is not letting their unit through that on-site manager, and there can be some disputes going on that the tenant gets sort of embroiled in. But bear in mind that on-site manager can't make decisions on the behalf of the body corporate, is not a decision maker for the body corporate. So if the tenant says, the on-site manager says, I can't do this or I must do that, you need to question that. Then you've got the body corporate manager. As I mentioned, they are non-voting members of the body corporate committee. Not all bodies corporate have them, but if they do, they're there basically to carry out, in effect, administrative duties for the body corporate. So again, they're not decision makers, but they'll manage the bank accounts, they'll send out notices, they'll show up at meetings and assist, and that's generally what they do. The body corporate manager must act according to the directions of the committee in most circumstances, and I guess when your tenant again says, oh, the body corporate manager said X, Y, Z, or told me I must do this, the body corporate manager doesn't have that power. So just check whether it was actually a decision of the committee passed through the body corporate manager, or if in fact your tenant needs to go to the committee to find out actually what's really going on, or put a request to the committee directly. So yeah, it can get confusing because without trying to go over the top, you could be, there's lots of different terminology used. There's for people that are involved with the body corporate, there's letting agent, there's on-site manager, there's caretaking service contractor, there's body corporate manager, and then there may be some random other contractors running around. So it can be quite difficult to work out who's actually doing what. But bear in mind, from your tenant's perspective, really, they're interested in what the committee is doing and deciding, and the body corporate as a whole. So that's body corporate managers. And that's basically it. Fairly brief. I know there's a lot more I could tell you, but there's a limit to how long I know you want to sit in front of your computer screen. So please, moving forward, please contact us on 1-800-060-119 up there, or use our website, or you can also send through an online inquiry. But moving forward, there are only more and more units being built and more tenants living in units, and our respective areas of expertise are overlapping potentially more and more. So please contact us, and we'll do our best to assist you with questions that may be to do with your tenant and their body corporate situation. So thank you for listening wherever you are in this great wide state. I hope it's a Friday afternoon and you can now go home, but if not, if it's a Monday morning, I'm sorry, carry on. Okay, thank you very much. And I'm now going to shut this down.